Have you ever considered the invisible trust that underpins every financial decision you help your clients make? It is a powerful bond, built on confidence and expert guidance. But what happens when that trust, specifically the legal obligation to act in their best interest, is called into question? When a financial advisor breaches their fiduciary duty, it opens the door to significant legal liabilities, primarily financial restitution for the client and severe professional consequences for the advisor. This includes potential financial penalties and lasting damage to reputation. A fiduciary duty is a legal and ethical obligation to act solely in the best interest of another party, typically a client. This means always prioritizing their needs above your own, avoiding conflicts of interest, and providing transparent, appropriate advice. A breach occurs when an advisor fails to uphold this high standard, whether through negligence, misrepresentation, or actively pursuing their own benefit at the client's expense. The legal system recognizes the unique vulnerability of clients who place their financial well-being in an advisor's hands. Consequently, courts and regulatory bodies impose various liabilities to make the injured party whole and to deter future misconduct. These can range from compensatory damages, which cover the client's direct financial losses, to disgorgement, where the advisor is forced to give up any ill-gotten gains. In egregious cases, punitive damages might be awarded to punish severe wrongdoing, although these are less common. Beyond direct financial repercussions, advisors can face injunctive relief, which is a court order prohibiting certain actions, and significant regulatory penalties. Regulatory bodies like the Securities and Exchange Commission, or SEC, and the Financial Industry Regulatory Authority, or FINRA, have the power to impose substantial fines, suspend licenses, or even revoke an advisor's ability to practice. The ripple effect of these actions can devastate an advisory practice, leading to a profound loss of client trust and severe reputational harm that may take years, if ever, to recover from. So, how can you navigate these waters and protect your practice? Proactive prevention is always the best strategy. This means consistently acting with unwavering loyalty and prudence towards your clients. Meticulously document every recommendation, every client conversation, and every disclosure. Ensure all client agreements clearly outline your responsibilities and their understanding. Transparency is key. Openly disclose any potential conflicts of interest, even minor ones, and seek your client's informed consent. Regularly review your practices to ensure full compliance with current regulations and internal policies. If you ever find yourself in a situation where a breach is alleged or even suspected, your immediate step should be to seek qualified legal counsel. A legal expert specializing in financial services can guide you through the complexities, help assess the situation, and strategize the most effective response to protect your interests and your practice. It is important to understand that the fiduciary standard is generally a higher bar than the suitability standard often applied to broker-dealers. A fiduciary must act in the client's best interest, while suitability requires that recommendations are merely appropriate for the client. This distinction carries significant weight in liability cases. Another crucial insider detail is the concept of material misrepresentation or omission. If an advisor knowingly provides false information or withholds critical facts that would have influenced a client's decision, this can form a strong basis for a breach claim. Furthermore, a robust professional liability insurance policy, often referred to as errors and omissions insurance, is not just a safeguard. It is an essential component of responsible practice management. This coverage can help mitigate the financial impact of legal defense costs and potential settlements arising from claims of professional negligence or breach of duty. Ultimately, understanding the potential legal liabilities arising from a breach of fiduciary duty empowers you to build an even stronger, more resilient advisory practice. By embracing the highest standards of integrity, maintaining diligent records, and ensuring complete transparency, You not only protect your business but also deepen the invaluable trust your clients place in you. This proactive approach ensures your practice thrives on a foundation of ethical excellence and sustained client confidence.